And this sometimes comes in, of course, with the surety that one gets that I can buy this off, and maybe if it doesn't materialize in the next 5 to 3 years, then maybe later. Look on the side of the publishers, the writers. Sometimes one buys a title. I had someone say, and then say the government or the ministry scraps the book off the syllabus. It's going to lay there, and who knows whether 20 years later it may be reported on the syllabus. So you're saying it should lie with that. But then we are not saying we should entirely scrap this. Our recommendation is that one, it can be put in legislation that when it comes to contracts of that nature, then it can be put, there can be a mandatory plain language kind of structuring of these contracts, that they are put in plain language that the creatives can understand. Number two, we can also think of statutory reversion rights where a work is not exploited within a reasonable period or in cases of breach. So for example, I assign you my work and I expect that in the next 1 year you're going to promote it, make it big, and then you simply buy it off as a way of just killing my career, and then you put it on the shelf and leave it there. So we can look at exploring such. And then lastly, we can also think of mandatory review clauses for long-term agreements. This is common practice in agreements, that you can always put in a review clause. Say, after 10 years, after 20 years, we can always have a review. So those are our recommendations, and we think that these measures will protect authors from exploitation while maintaining the commercial flexibility and investment attractiveness essential to Uganda's creative industry, and also not alienating us from best-known international practices. We move on to Clause 6, which is Section 13B of the Amendment Bill. This particular one addresses, this is the one concerning technology, technological protection measures, TPMs. We are very, very, very much happy about the insertion of this particular section, given the times that we now live in, that most of our creations are not being exploited on physical gadgets like the CDs. Even books are being now sold online. So we believe that this is a very good insertion into the amendment. However, in our own view, we feel there is some ambiguity in this particular section. For example, I'll go straight to where the ambiguity is. Subsection 1, it appears to criminalize mere possession of circumvention devices without requiring proof of intent. So here we're simply highlighting where we think it is quite ambiguous, such that the lawmakers can always find better ways of how to put it right. Then subsection 3 provides for exceptions for security, education, research, and beneficiary persons. But it is unclear on whether these apply to all prohibited acts or only to acts of accessing the works. Then on the compensation provisions, it reference a victim, but do not specify whether this includes the copyright owner, the licensee, or platform provider. So I think the bill would have to come clear on who the compensations should go to. Because this ambiguity risks criminalizing legitimate uses such as repair, accessibility for persons with disabilities, archival purposes, and lawful research, which is contrary to Uganda's commitments under Article 10 of the WIPO Copyright Treaty and Article 13 of the TRIPS Agreement, which recognize the need for exceptions that promote education, accessibility, and innovation. So what are our recommendations? We recommend that Section 13B be revised to incorporate clear and operational definitions for key terms and to clarify the scope of both prohibitions and exceptions, in particular. 1, effective technological protection measures, commercial purposes, beneficiary person, victim, and limited commercial significant purposes should be expressly defined in the law.